tell the truth and a penalty and perjury of the law. Ms. Jackson Brown, is that a yes?
Yes.
Mr. Henry Jenkins, is that a yes?
Yes, sir.
All right. Folks, I'm going to have you both mute yourselves, and I'm now going to hear from Attorney Herring regarding her motion to dismiss. Counsel.
Yes. Good morning again, Judge Davis. I am Jolanda Herring, and I'm here with my law partner, Stanley Foster. We represent Mr. Henry Jenkins Jr. He's the defendant in this action. He is on the line with us.
Hold on. Okay, I just want to make sure. Ms. Jackson Brown, please make sure you're paying attention, all right? Thank you. You can continue, Attorney Herring.
Your Honor, it's Mr. Jenkins' position that Ms. Jackson is attempting a fraud on the court. Mr. Jenkins owns the property that she's attempting to dispossess him of, and she well knows this. Just as a quick, brief background, Mr. Jenkins was in a long-term committed relationship for a few decades with Ms. Jackson's sister. Her name was Clemmy Hill. Ms. Hill passed away March 5th, 2024, leaving a will. In her will, she left her entire estate to Mr. Jenkins. And Ms. Jackson was well aware of this because she received 2 copies of the will prior to Ms. Hill's passing.
The court hearing begins with both parties, Ms. Jackson Brown and Mr. Henry Jenkins, confirming that they will tell the truth under oath. The judge then instructs everyone to mute themselves and invites Attorney Jolanda Herring to present her motion to dismiss. She introduces herself and her law partner, explaining that they represent Mr. Jenkins, who is the defendant in the case. Before she proceeds, the judge reminds Ms. Jackson to stay attentive. The attorney then outlines their position, stating that Mr. Jenkins believes Ms. Jackson is committing fraud upon the court. According to the defense, Mr. Jenkins is the rightful owner of the disputed property. The situation dates back to his long-term relationship with Ms. Jackson's sister, Clem Hill, who passed away on March 5th, 2024. Before her death, she left a valid will that granted her entire estate to Mr. Jenkins. The attorney emphasizes that Ms. Jackson was aware of this will and had even received copies before her sister's passing.
Despite this, while Mr. Jenkins was actually still grieving, Ms. Jackson went down to probate court and falsely told the court that her sister had passed away without a will. Ms. Jackson did not provide a copy of her petition to Mr. Jenkins, even though she realized he was the sole beneficiary under the will. Believing that Ms. Hill died without a will, Judge Hargrove granted Ms. Jackson's petition. Ms. Jackson's first action with her new authority was to evict Mr. Jenkins from the home that she realized that he had inherited. Mr. Jenkins, of course, immediately petitioned and filed a petition to probate the will, and Judge Hargrove limited Ms. Jackson's authority. And in that order, she directed Ms. Jackson not to take any steps to divest or otherwise dispose of the property that's owned by the estate. And later, because the will was deemed valid by Judge Hargrove admitted it to probate. She appointed Mr. Jenkins as executor, and she revoked Ms. Jackson's letters of administration and, of course, her authority. And in that order, Your Honor, Judge Hargrove explicitly told Ms. Jackson to turn over all assets in her possession to Mr. Jenkins within 20 days. This was well over a year ago, Your Honor. This order was entered February 7, 2025. Unbeknownst to everyone, including Judge Hargrove at the time, Ms. Jackson had transferred via an administrator's deed the property to herself. When we learned of this, we filed a motion for contempt in probate court that's currently pending, and we also filed a motion to cancel the deed along with a notice of lis pendens. Those 2 are also pending in Superior Court. Undeterred, Ms. Jackson has now returned to magistrate court for the 3rd time, Your Honor. She's relying on the deed that she unlawfully executed to herself, and now she's asserting a claim for possession. Your Honor, there are at least 4 reasons that this action should be dismissed. First, Ms. Jackson doesn't have standing. She's relying on the administrator's deed that was revoked.
Despite knowing about the will, Ms. Jackson allegedly went to probate court and claimed her sister died without one. Based on that claim, she was granted authority over the estate. Soon after, she attempted to evict Mr. Jenkins from the property he had inherited. In response, Mr. Jenkins filed a petition to probate the will, which was later confirmed as valid by the court. The judge then appointed him as the executor and revoked Miss Jackson's authority, ordering her to return all estate assets within 20 days. However, it was later discovered that Miss Jackson had already transferred the property to herself through an administrator's deed. The defense filed motions to challenge this action, and those matters remain pending in higher courts. Despite this, Miss Jackson returned to court again, relying on the same disputed deed to claim possession. The defense argues that her case should be dismissed because she lacks legal standing, the court has no proper jurisdiction, and there is no landlord-tenant relationship between the parties. Additionally, she failed to provide the legally required notice before filing the eviction action.
Well over a year ago. In addition, Your Honor, this court doesn't have jurisdiction because even though it's disguised as a dispossessory action, it's not. It's really regarding the illegal transfer of title that's pending in Superior Court, as well as some portions of it in probate court. What it's not also, Your Honor, is a landlord-tenant relationship. There is no lease, no rent, no tenancy created, and Mr. Jenkins's possession actually arises from his position as executor. And finally, Your Honor, Ms. Jackson failed to meet the statutory requirements. She did not demand possession within 3 days from Mr. Jackson prior to filing this action. And that alone, Your Honor, is fatal under Georgia law. So, Your Honor, we respectfully request that you dismiss this dispossessory warrant in its entirety.
Okay. Ms. Jackson Brown, your response?
First of all, Your Honor, my sister did not have a will. Second, Your Honor, the will got notarized 5 months after my sister was dead. Second, Your Honor, we filed an appeal on the will that made his executorship halted. First, Your Honor, I didn't put him out. Judge Davis, Joshua Davis, put him out because he would not pay the mortgage. And furthermore, Your Honor, he had rats all in the house. They ran after the marshals. Okay? He did not pay the mortgage. The judge gave him 60 days to pay that mortgage, to bring that money to the courts, $4,700. He did not bring that money to the courts whatsoever. The judge sent the marshals to put him out. Georgia law states, once the marshals put you out, you cannot break back in a property. Once magistrate court remove you, then you're supposed to appeal magistrate court. Okay, once I appeal that will as fraudulent, that you could not file anything after that. The will was appealed. You had to stay in motion to stay for once I filed that will, you had to stay in motion to proceeding to maintain status quo. You could not continue filing stuff after the appeal was filed. And that's why the appellate court got mad with them and sent them that notice, telling them they cannot file anything on Gloria Jackson. That's what the appeal. He's had 3 attorneys, Your Honor. When I filed that appeal, his first attorney was Cameron. He the one notarized that will 5 months after my sister was dead. She could not even write, Your Honor. Her hands were curled up. Her medical report states the doctor even states his medical report.
Well, Ms. Jackson Brown, I don't want to get too much off topic. I guess really let me just ask a couple of questions just so I can understand just the basis of what's going on. I did give you an opportunity to speak. One I take it this was your sister, correct?
Yes, sir.
Okay, and at the time, you're saying you were unaware that there may have been a will. Is that correct?
No, didn't nobody know nothing about no will.
That's what I'm saying. You knew nothing about a will, and then
okay, when I put him out, then
let me just ask some questions. It's all right. Just
yes,
simple
sir.
questions. You don't got to go in. I just want to make sure I understand the position. Okay, simple
yes, sir.
All right. So you filed a probate action after your sister passed away. Is that correct?
Yes, sir.
All right, and then you later found out that there was a will that was alleged to have been made. Is that correct?
Yeah, after we put him out.
Okay, and you're saying you had put Mr. Jenkins out. He was evicted by the marshals. Is that what you're saying?
Yeah, he was convicted by the marshals.
Okay. But is he still living the property?
After the marshals evicted him out, he broke back in the property.
Broke back in the property. And you say Judge Joshua Davis gave that order?
Judge Joshua Davis made that order to remove him because he would not pay the mortgage.
Okay. Do you know what that case number is?
Yes, sir.
Okay. What's that case number?
That case number is 24D
Oh,
28564.
okay, hold on. So this was almost 2 years ago that this happened, is what you're saying.
And he broke back on the property, and I kept calling the police over and over again. He
Okay.
took the boards off, broke my lock, and the police said I had to take him back to probate court. And I told him, no, this is against the law. He can't break back on this property because the law states once the marshal.
Well, I hear you, and I do see that the initial motion was denied, and I do see that there was a dispossessory warrant. Let me see.
And it went into default.
Okay, so I see. I believe I briefly remember this was back in November 2026. This was
Yes,
an
sir.
in-person calendar, and he appeared. And I think at the time you must have been the administrator or something of that nature. And so then, Miss Herring, you're saying since that time things have changed.
Yes, Your Honor, you are exactly correct. She was the administrator at the time that she filed the initial act.
Okay, so I'm not crazy then.
Yes, Your Honor.
So, all right. It was like, okay, so you're saying since that time her administration has been revoked.
Correct, because she became administrator because she told the probate court that there was no will. So whenever they dispossessed Mr. Jenkins, of course, he quickly filed his petition and the original will, which Judge Hargrove has since probated, admitted, and he is now the executor. And Judge Hargrove revoked her letters of administration.
Let me ask you about this, counsel, because I am concerned, and I'm going to just not spend too much time. At the time, Miss Jackson Brown back in 24 indicated that the property was about to go into foreclosure because there was no mortgage being paid or anything of that nature. And I did order him at the time to pay some money into the court, which I guess I believe he didn't do. That was a concern, I guess, because the allegation I think is that he was living there and it was about to go into foreclosure. Is there any information as to that?
Well, Your Honor, I wasn't his counsel at that point, but there was a subsequent action filed by Ms. Jackson to enforce your order.
Yeah.
By the time that was filed, she was no longer administrator, so she didn't have standing to bring any actions on behalf of the estate, and he was executor at that point. So she pretty much abandoned that because she didn't have standing to bring the action.
I get it.
Excuse me, Your Honor. When he filed that will and we filed the appeal on that will, his administration halted when appeal court accepted my appeal.
Well, so Ms. Jackson Brown, to that same point, then yours would also be halted, right? Because yours
was halted.
So within that regard, how do you then exert authority when all of you guys' powers are halted?
Because everything they filed, appeal court, they didn't file with appeal. My appeal went unopposed, and appeal court sent them a letter telling them that they cannot file anything on Gloria Jackson because her appeal been in since June of last year. So that's what they told them. So
what I'm going to do is since there's an appeal and all of this really is around a Superior Court issue, I'm just going to hold on this matter. And so, and I'll be frank, if there's no quick establishing a clear a landlord-tenant relationship at this juncture because of this probate issue, it wouldn't be appropriate for me now to reissue a writ of possession when things have significantly changed and there are appeals being made. So I think
he broke back in the property, though, Your Honor. That's against the law.
Well, but then there's an allegation that he had a will and he had rightful potential ownership at the beginning, which is something to that's important enough to address, and the Superior Court has authority to address that. So what I'm going to do is, in this case,
but I have the appeal letter right here, Your Honor, stating that they cannot file anything on Gloria Jackson.
And I think in that regard, I think that makes great sense. So I'm just going to hold on this case because it doesn't appear that you have any agreement with this gentleman. So it's not like he owes you any rent or anything of that nature. It's really of a dispute about ownership at this point, and that's not really appropriate for me to make a decision on. That would be more appropriate for the Superior Court. So I'm going to hold this matter.
But he tried to sell the house, Your Honor.
Okay. Well, again, that would be either something that would be more appropriate for the Superior Court, and if there's an appeal, then you're telling me there's a hold, then he can't do anything either. At least he shouldn't. So I'm going to hold.
So what about the mortgage not being paid?
I guess that would all be something that would be addressed in the probate issue now that there's appeals being dealt with, and more information is being presented to me than maybe was presented to me initially in 2024. So counsel.
Your Honor, I'd just like to clarify, there is no appeal pending by Ms.
Yes,
Jackson.
there is an appeal. They was not his attorney. He's had 3 attorneys. They the third one. Now, appeal court already told him there was an appeal. They sent him an email.
Ms. Jackson Brown. So let me do this. I'm going to give you an opportunity to give me whatever documentation you're talking about. All right.
I sent it to you already, Your Honor.
Because I don't see any documentation.
I sent all the documents. I uploaded, sent it to you, and the court said they received it.
Okay, maybe I don't clearly see the appeal information. Hold tight. Give me 1 second. Now, of course, I have to ask too while I look up this information. Did you send him a demand of possession?
So where, Your Honor?
Did you send him a demand of possession? Did you properly notice this gentleman before you pursued with this action?
Well, he broke back in the house, Your Honor. That was against the law.
So you're saying you're not required to do any of the notices by virtue of which you believe he's broken the law? Is that what you're saying?
Exactly. When he burglarized and took the locks off, he burglarized the house.
Okay. Counsel.
Your Honor, the mortgage is current, and Mr. Jenkins did not break back into the home. He is executor. The home has been bequeathed to him under the will.
There was no will. My sister was too sick to write a will. She was on morphine. That's why the appeal court accepted it.
So this Jackson,
my sister was on so much morphine she couldn't write anything.
Miss Jackson Brown, don't make me mute you, okay? Respectfully, just don't overtalk people. That's just not what we want to have done.
I'm sorry, Your Honor. My apologies.
This is your sister. I understand this is a long, drawn-out issue, but ultimately, that doesn't mean you get to say and do whatever you want because you're emotional, okay?
My apologies.
If you haven't given him a demand of possession and there have been changes in the Superior Court about the overall authority, then I'm not going to give you authority to get rid of possession again. And if you have not properly noticed him again and you subsequently believe that you needed to file a dispossessory action, because this is not an intruder's action. This is not an action assuming that this individual is there without any authority at all. That means you have to follow that process if you're going to use this process. And if you have not demanded possession, even if everything else that you may have been saying is true, that case is going to render a basis for this matter to be dismissed. Yes. Now, again, since the matter is still pending in Superior Court, you may come back. Who knows? But if you have not done what is needed to be done appropriately today, I can't give you anything anyway. And so for that reason, I am going to grant defendant's motion to dismiss because you pretty much admitted that you didn't do anything because you believe he didn't need to be there at all. But obviously, quite a few things have changed since that time. So, counsel, I'll look for that proposed order that grants your motion to dismiss. And then, Ms. Jackson Brown, I'm not the Superior Court. I'm not telling you what the final statement is about ownership. I'm just saying as far as today, what's going on and what you've communicated today isn't going to give me any authority, or at least convince me to give me authority to give you rid of possession. So I'll look for that order, counsel, and Ms. Jackson Brown will get you a copy once we review it and sign it, okay? And that'll be the order of the court. You both are free to go this morning.
Your Honor.
Your Honor. Hold on, I'll hear from Ms. Jackson Brown one last time, then I'll hear from you, Attorney Hearing. Yes, Ms.
Your Honor. So what you're saying is that I'm gonna have to wait till the appeal court finish their ruling, or I got to give them 30 days. Or is that what you're saying?
I'm not saying either one of those things. I'm just saying for today, you haven't done what's required for me to do what you want to do. I don't know about the appeal. I don't know about all of that.
I sent you everything, Your Honor.
But it wouldn't even be my authority to rule on that, since you're telling me that it's pending. You understand? I'm not going to make any order that's going to be either derogatory or step on those toes of those folks in the appeals court. So the case is dismissed for the basis of not providing the proper pre-notice, like a demand. And then from there, if you're free to refile, if it's your authority is reissued, okay?
Yes, sir, Your Honor.
Your
All right.
Honor,
Yes,
Your Honor,
counsel.
Your Honor, we do have a counterclaim that we filed as well. Would you like us to
No, I'm going to
come back with
grant
this?
your motion to
We're
dismiss.
concerned that Ms. Jackson is going to continuously file. I mean,
And she may. And so since this isn't the finality of this matter, what I don't want to have necessarily done is this matter continue to proceed on and then we have it. So what I'm going to do for today, because honestly, she had a rightful writ initially, and obviously things have changed and that happens. And
Yes,
so
sir.
now she's refiled. She's saying there's appeals. And so I'm going to grant your motion.
Yes,
And
sir.
we're not proceeding on anything else as far as the claim today. And so those matters will just be dismissed without prejudice. You can free to bring them now. And obviously, you do have a pending, probate matter. I understand there might be claims you could bring in there, but if it's brought again, we'll address it then. Otherwise, you're free to file them or pursue them in that other matter. And if she does it again and she doesn't have any authority, then we'll explore it. Okay.
Yes, Your Honor. Thank you very much, Your Honor.
All right. Thank you. I'll look for that order.
Thank you.
Thank you. Thank you, Ms. Brown. Thank you, Mr. Jenkins.
Can I ask you one question, Your Honor?
This is the last one because I'm patient.
Can I send you the stuff that I have?
You can file whatever you need that is relevant into the case, okay? But the motion
All
to
right.
dismiss will be granted. Thank you.
Okay, thank you, Your Honor.
Yes, ma'am.
Thank you, Your Honor.
You're
Thank you.
Miss Jackson responds by denying the existence of a valid will and claims it was created after her sister's death. She argues that Mr. Jenkins was lawfully evicted due to unpaid mortgage payments and poor living conditions. According to her, he later broke back into the property unlawfully. The judge listens carefully and asks questions to clarify the timeline and legal positions of both sides. It becomes clear that multiple legal actions, appeals, and conflicting claims are ongoing in different courts. The judge notes that the case is no longer a simple eviction matter, but a complex dispute over property ownership. Since there is no clear landlord-tenant relationship and the ownership issue is still under review in higher courts, the judge decides not to proceed with eviction. He also highlights that Ms. Jackson failed to follow proper legal procedures, such as issuing a formal demand for possession. As a result, the judge grants the defendant's motion to dismiss the case for now. He clarifies that this decision does not determine final ownership, which must be resolved in the appropriate court. The hearing concludes with both parties being informed that they are free to pursue their claims through the proper legal channels.